I'm Cecile, and I'm the coordinator for the Maji Center at NATE. We're focused on helping NATE students go from idea to launch, but we like to share our events with everyone because we think they're just awesome. At NATE, we honor and acknowledge that the land on which we learn, work, and live is Treaty 6 territory. This place is a traditional homeland for the First Nations and Métis peoples, and today we are all part of this treaty land. The traditional name of this place is Amiskwachi Waskigan, which we also call the city of Edmonton. I'm very happy and fortunate to be able to introduce Craig Sherburne, who is CKS Legal. That's Craig, but also he is one of our valuable mentors for our student entrepreneurs and has led us in several sessions. But today we're focused all on incorporation. So over to you, Craig.
Well, thank you. I'll warn everybody in advance that I try to make my presentation funnier each time. So this might be my third or fourth time I've given this presentation. So this one should be a real barn burner when it comes to corporate law matters. So just, hold on to your seat. What would be the phrase? You might have paid for the full seat, but you'll only need the edge as we go through corporate law for beginners and the stories that come through it. One of the things I like to do is to answer common questions. So there are 5 questions I get asked every time by new entrepreneurs, and I'm going to answer the first 4 quickly. These are the most common entrepreneur questions. When do I get to sell? And easy answer, when somebody wants to buy you, not a day before. It's really hard to sell something if nobody wants to buy it. How much will I get when they sell? Well, that one's another easy amount, easy number. Everybody expects me to value their business. I don't have to value your business. You're going to sell your company for the highest they're willing to pay and the least you're willing to take. So, boy, we just cut off 2 real quick questions. How about the third? How much of my business do I have to give up to investors? Well, that's the least they're willing to take and the most you're willing to give. And my favorite question is, how much do I have to offer to investors or financiers? And this one is 100% true. Don't worry, they're going to tell you what they want. You might be able to think ahead and say, well, how can I make my company or my business look like something they want? That's a very valuable question. And that's a very valuable question to ask yourself and then address. But investors and financiers are usually very good at telling you exactly what they want out of it because they've got the money and you need it. Something to keep in the back of your mind is there's this common element I've seen when it comes to any financing or any investment or any funding of a company, and that is that the people with the money undervalue the time and effort that the founders have put in. And the time and effort, the founders always undervalue the money that the investors are going to put in. So the investors think the money is the most important thing and undervalue how much effort you put in. And you think the effort's the most important thing and undervalue the money. And as long as you actually understand that that's inherently going to be the tension between both sides, you can actually get to really good deals by saying, okay, here's somebody who doesn't necessarily value how much time and effort I put into coming up with my brand or with my logo. So if they're not going to appreciate how much time and effort I put into my logo, what can I do to make this business attractive to them? And usually the answer is make it profitable. You want money, make it profitable. But the 5th question, here we got 4 quick questions right off the top. And I'm going to take a pause and just say there is a chat window. If anybody has a question during this, feel free to enter it into the chat. It'll come up to me and I'd be happy to answer it while we're going through. Otherwise, there will be time at the end of this to chat. Okay, enough for that side. What is the 5th most common question I get? And that is, do I need to incorporate? And so we're going to spend the rest of this session to talk about what is a company? Do you need a company? And when should you consider having a company? And there's no easy answers, but I might be able to give you the tools to be able to start answering the question yourself after this presentation. But as I am wont to do, I never like to talk about the law directly. I instead like to talk about stories. So here comes a famous Craig Sherburne metaphor or analogy or a story that people will that people will come up to me later and talk all about for years to come. So I want to introduce you to a guy by the name of Archibald Reginald Wilkins III, or Archie. Now, Archie has this brilliant idea. He wants to get into door-to-door sales. and he wants to sell door to door 2 different kinds of cold beverages. He's got 2 products in mind. One is a lemon lime flavored soda, and one is a lemon lime flavored laxative. Now, the thing you got to understand about the door-to-door business, door-to-door sales business, is it's all about margin. So he wants to keep his costs low. So Archie has this brilliant idea of putting the laxative and the soda in the same kind of can. It's got the same brand, it's got the same colors because they're both lemon lime, but he's no fool. He's going to identify his laxative cans by putting a sticker on the outside that says, this one's a laxative. Brilliant business model. Door to door, selling soda and or laxative, but he's no fool. He's going to have a sticker on it for the ones that are laxatives. So Archie decides that he's going to incorporate Bob's Sales Inc. because for some reason that's his nickname, Bob. Now, why does he incorporate Bob's Sales Inc. to sell his soda and laxative door to door? Well, a couple of reasons. The first, he wants to have the profits for Bob's soda and laxative taxed separately from his income. He has a day job. He makes $50,000 a year in his day job. He isn't interested in being taxed for what he makes selling soda and laxative. Second, he's afraid that his business might get sued. I mean, he keeps hearing about how companies out there, the more successful they are, the more that people want to sue them. He's worried it might be doxxed. He doesn't want people to know where he lives, so he wants to have a company that has a different address. Mostly he's worried about the pro-constipation activists. We know all about how they're out there in the industry and how anti-laxative they are. So he goes to the registry's office. He pays his $400. He gets 5 pieces of paper, and he creates Bob's Sales Inc. And he then goes off on the road with his cold cans of laxative and soda that he's going to go door to door to sell, knowing that he's good because he's got a corporation. He's not going to get sued. If the corporation can get sued, he's going to be taxed independently, and nobody can find out where he lives because they can only find out where the company lives. But then this happens. There is what can only be described as a traumatic and devastating accident, as somebody who has purchased a celebratory soda from him in a balloon as he proposes to his wife at 1,500 feet up in the air has a tragic accident. I would call this the Oopsie Poops. Clearly, there's been some error that's happened where they drank a soda, but they'd actually drank the laxative. Now, the question becomes, did incorporating help Archibald? Was the corporation going to help him? And before I can answer that, we're going to come back to this, but before I can answer that, we need to understand what it is that a company really is. And to answer that, we have to understand that a company is recognized in law in Canada as being a person. Individuals are persons. Corporations are persons. Trusts are persons. Partnerships are persons. But that's different than an individual. So a person or a corporation can hold property. A person can enter into a contract. It can conduct business. It can pay taxes. All the really important things that the government cares about. Individuals can do the same thing. They can have property. They can enter into contracts, but they can do some things that corporations can't do. An individual can die. An individual can give away things and give gifts to people. An individual can throw a baseball or throw a punch. Well, a corporation cannot, because a corporation is a legal fiction. A corporation is a bundle of papers, and simply the fact that the law will recognize that a corporation exists and can do certain things. So because of that, a corporation, which is simply some pieces of paper, sometimes in a binder, sometimes in a duotang, sometimes pieces of paper just left at the bottom of a tray of a printer. But since a corporation is really just pieces of paper in the physical world, it has no arms, it has no legs, it has no mind. It actually has nothing that it can interact with the world with. It needs to have individuals that do things on behalf of the corporation. And those individuals start with what are called the directors of a corporation. So the directors are the brains of the company. The directors of the corporation have all right and authority to do things for and on behalf of the corporation. They are the ones that at one level, they provide the big picture direction to the day-to-day operations of the company. So if we think about TELUS, it has a board of directors. Well, there's no way that you can ever imagine a director of TELUS showing up at your door to install a phone. They don't, but they do have all the power and authority starts with them. And they do have the ability to hire people, which they then say, you need to go out and install telephones for people, but don't make sure if you're going to install telephones for people, you give really vague periods of time that you're going to show up to their house, and then make sure you never show up there at that time. So that, I mean, I think that's pretty much the directors of TELUS's main communication to its employees, if my experience has been accurate. So the power starts with the directors, but companies also have these things that are called agents. And so an agent of the company is the hands, the eyes, the ears, the legs of a company. Agents can be the officers, the named officers, the chief executive officer, the treasurer, the secretary. These are examples of agents of the company. This is an individual that can do things. You cannot have the president of a corporation that is themselves a corporation. That doesn't make any sense. That's impossible, because then you have a bundle of papers that's acting on behalf of a bundle of papers, and that doesn't work. You need to have an individual appointed as the officer. Companies can also hire contractors, lawyers, accountants, consultants, bookkeepers. These people become agents of the company, but their powers are limited by contract. So if you hire a lawyer, it says, this company wants you to go and do these things. The lawyer can't do things for the company that aren't explicitly allowed by the contract. Similarly, the powers of employees, who are also agents, are limited by the contract. The important thing here is that every one of these examples, officers, contractors, and employees, they are appointed by the directors. The directors have the power, and then they give some of that power to their agents. You can think of the powers of a company as a waterfall. It starts at the top with the directors, and then they will pass some water down the chain. They pass off and delegate some of the authority, which starts with the directors down below them. And the reason I'm really pounding on this is people don't really understand often when they come into my office exactly what kind of powers a director has. They will come into my office and say, I have a company and I'd like to have 3 people I met on the bus yesterday become directors because they look smart. And it's no, if you don't know these people, you are now giving them the power and authority to act on behalf of this company. That's not the right role for them, because everything in a company starts with the directors. So we look back to Bob, or Bob Sales, with Archie starting Bob Sales, and we ask the question, just as a reminder, well, did incorporating help him? Well, he was a one-man operation, which means when he created the company, he was the sole shareholder, he was the sole director, and frankly was the chief cook and bottle washer. He was an officer, he was an employee, he was an agent, he was a director. So he was all those same things. So did that help him? Well, let's start with what exactly is a shareholder. So notice when I listed the 3 agents of a company, employees, officers, or contractors, I never said anything about shareholders being agents of the company. And that was intentional, because a shareholder is not. A shareholder is not one of the 3 categories of individuals that can do things for a corporation. Shareholders only get to do 3 things, and they can only get to do up to 3 things. Sometimes they don't even get to do all 3 things for any one shareholder. Shareholders get to vote at a meeting, and at that meeting, the vote is essentially who's going to be the director of the company. That's the primary goal of that meeting, and that happens once a year. A shareholder can participate in the profits of the company, and a shareholder can receive the assets of the company when it winds up business. That's the 3 things a shareholder can do. Shareholder can't go and sell on behalf of a company. A shareholder can't sign contracts on behalf of a company. A shareholder only gets to vote once a year and then share in the profits. And those profits it shares in, by the way, is only when the directors allow it to receive profits. Okay. Oh, pardon me. There we go. So shareholders is a completely passive role. That passive role is reflected in the fact that shareholders do not receive any of the liabilities of the company. If the company owes money, the shareholders do not owe money. That's the company's problem. The shareholders also receive almost no liability for the actions of the corporation. If the corporation goes out there and does things and hurts people in some fashion, the shareholders do not take responsibility for that. There are a few exceptions, but they're mostly confined to environmental protection laws. So we had a problem in Canada where oil companies were creating companies owned by companies, and then saying that well, the damage to the environment that was created by leaking oil or gas that was leaching into the environment, that wasn't the problem of the shareholders. And so we created some very specific laws that could say under certain circumstances, a shareholder might be held liable for the wrongs of the company. But it's really very limited, and it's usually related to environment. So we can start with the statement, shareholders are completely passive. Completely passive. So going back to Archie, we know that he was a shareholder, and he was protected from the liabilities of the company. In particular, to remind everybody, what is the liability of the company? It's that some newly engaged man drank something that he thought was a lemon lime flavored soda, but it was instead a lemon lime flavored laxative. So there's a fear of being sued. So Archie says, it's great, I incorporated, I don't have to worry about getting sued because as a shareholder, I can't be sued. And that is absolutely correct. But the problem is that Archie wasn't just a shareholder. Archie was also a director, officer, and agent of the company. Further, he was the guy that actually sold the lemon lime flavored soda that actually turned out to be a laxative to this newly engaged individual. So he might not be liable as a shareholder, but incorporating the company doesn't save him because he's liable as a director of the company, which as a business plan engaged in risky behavior. You should never sell laxative and soda in the same kind of can and simply apply a label to one that says this one's a laxative. He is also liable as an officer of the company, in this case for carelessly supervising the application of it's a laxative label or using low quality adhesive so that the label, this one's a laxative, fell off. And finally, he's also liable as an agent of the corporation for negligently selecting and pressing the label to the cans. So incorporating didn't save Archie. I'm going to take a pause here because one of the joys of owning your own office is you get to choose who you bring to the office. And I bring to the office every day my St. Bernard, who sits behind me and curls up. And so if you hear snoring during my talk, I can assure you it's not anybody participating in the talk. It is my St. Bernard that is snoring loudly behind me. So don't think that I'm giving anybody a permission to fall asleep during my talk. Okay. So incorporating didn't save Archie. So why would you incorporate anyways? Well, there are some clear advantages for a corporation, and there are clear advantages for incorporating, but they're not everything that everybody expects them to be. So the first is that corporations 100% isolate the liabilities from the shareholders. But that doesn't really help if the shareholders are also the same as the directors and are also the same as the officers and the agents of the company. So if you've got people who want to passively participate in the company, corporation is the right way to go. To make sure that the liabilities that the company might incur, somebody slips and falls outside the company's offices, they're not going to be felt by mom who wanted to invest as an early investor in the company. Corporations are independent people. So the liabilities of the company under contract are separate and distinct from the liabilities that you as an individual might have. Companies can hold properties, they can enter into contracts, they can pay taxes separately from its shareholders. That one's really important when there's profits. So I don't want to turn this into a tax discussion, and this is highly inaccurate, but it's a good way to at least approach tax in Canada. We have two taxation systems in Canada. One taxation system is for corporations, one is for individuals. Individuals are taxed at a higher rate than companies are. It's just the way we do things here. Your highest tax rate for an individual is right around 42 to 45% in Alberta, depending on where you're at in the tax bracket. Your highest tax rate for a company earning less than $500,000 profit a year is right around 21%. So you can immediately see that corporations paid like nearly half the tax that individuals do. So, but the other element is that when the money has to leave the corporate system to get into the pockets of the individual, that's when 21% is taken off anytime you transfer it out of the corporate system into the hands of an individual. That's where that you're going to feel that pain. So if you've got money coming into your pocket as an individual, you're paying 42%. If you have money coming into a corporation for its business, you're paying 21%. You will have to pay the difference when you want to get it out of the corporation and into the hands of an individual. Fine, dandy. But there's some real benefits to maybe deferring or waiting for that to happen. So the fact that the corporation is a separate, independent taxpayer, that's meaningful. The big one for corporations, though, is the fact that a corporation can have multiple shareholders, which means you can share the profit easily between a number of different individuals, for example, investors or a number of different founders. When the profit comes at the end of the year and you say, we've got $100, there is a very established legal system in place and very established business system in place for how you're going to get that money from the company down to your participants in the company, namely a dividend. Okay, we've got $100, we're going to issue a dividend. So every shareholder, since we have 100 shares, every shareholder is going to get a dividend of $1 per share. That was easy. How do you do that as a sole proprietor starting a business? You go to your neighbor and go, you've always been there for me, and I've been using your bottling plant for putting my soda and laxative in cans. I'd like to give you 10% of everything, all my profit that I make at the end of the year. Great in theory. What's the paperwork look like for that? How do you explain to your accountant or the tax authorities at the end of the year why you wrote a check as the company to your neighbor for $10 if you made $100 profit? Because I can assure you the CRA is going to go, well, that wasn't a business expense. You tried to give a gift, and corporations can't give gifts. Individuals can give gifts, but we think that this was something different. So you know what we're going to do is the CRA might take the position that they're going to tax you as if you received all $100, and then they're going to tax your neighbor as if he received $10, and you go, but that seems wrong. And the CRA would say, well, you didn't do your paperwork right. At least in a corporation, you've got all the paperwork all set out there. I'm not a big fan of the CRA, by the way, and nothing of I'm saying is to be considered a legal opinion on the CRA, but I can tell you that sometimes unfair results can happen when you're talking with a governmental agency, particularly the revenue agencies, and those unfair results come from just bad documentation. So it's hard to share profit between individuals. So all of here is the advantages of a corporation. That's wonderful, that's fine. So it's a great way to do all these things. And it's so easy to create one. That's more importantly. I have so many people who come into my office, they go, but creating a company was so easy. It's so easy to do wrong. A lot of people feel that you just pop down to the registry office. Now it's actually, there's been a couple of online entities, online businesses that have started up that they've partnered up with registry offices. So you can even go online and incorporate either federally or provincially in minutes. And to do this. So it's so easy. You go to a registry office, you go onto a website, you pay $400, you start issuing shares, and step 3, as it always is profit. 3 simple steps. Well, that's a great way to do things wrong and to get yourself into trouble. And that there's some really avoidable problems that people just never avoid. So the first is the legal requirements to a company. There's some securities issue. The securities are not just publicly traded stocks. Securities extends all the way down into any shares of any private company. Sometimes you can even find that securities are things that you wouldn't think are securities, like a promise to pay your neighbor 10% of your profit because he lets you use your bottling plant. You just issued a security, even though that security was simply a handshake and a promise. Taxes, there's some real common tax problems that we'll touch on. We'll also touch on some of the problems of just having shareholders. And the final one is a little more ephemeral and weird, but okay, you've incorporated, but what does your company actually own? And have you put the ownership of what the company is supposed to have in a form that somebody else would also recognize. So the first one are the legal requirements. So particularly the registry office, it's a real problem because they'll hand 4 to 6 pieces of paper over to somebody, and one of them says certificate of incorporation, and people think that they're a company, but they're not. The law is really, really clear. You need to have organizational minutes of your first meeting of the shareholders, first meeting of the directors. You need annual shareholders and directors resolutions. You need to file annual returns. Those annual returns will list to the government the addresses that the company can be reached at, who the shareholders of the company are, who the directors of the company are. By law, you have to maintain a register of who the directors and shareholders are. And more importantly, if people off the street want to come in and take a look to find out who the directors of a company are and who the shareholders are, they can show up at the records address. And by law, you have to show them these pieces of paper. It happens rarely. I'm not going to pretend this happens all the time, but it happens often enough that people are caught off guard by it. I have had a sheriff show up at, I've paid a sheriff to show up at a house in Calgary, knock on the door and demand to see their shareholder register. And the sheriff then reports back to me that somebody said, my what now? Well, that's because somebody went to a registry office, incorporated, listed their house as the records address, and then didn't step through any of these things. And I knew they didn't step through it. And so I had the sheriff show up, swear what's called an affidavit to say they had no shareholder register, they had no director register, they had none of the materials by law that they were supposed to as a corporation have. And then I used that on behalf of my clients, who I can assure everybody were the good guys, against the people who incorporated by simply going down to a registry office. Another element which a lot of people miss is the registered and records office. You need to have a registered address and a records address for your offices. Those are places where people can show up to demand to see certain records. But more importantly, it's also where people would send lawsuits, statements of claim if they wanted to start to sue the company. There's some real good reasons why you may not want to have your house as your registered office. That can be a real problem. A lot of these problems on this slide have been alleviated by the online services. So when you go to, I think it's called owner.co, and it's super cheap too to go to owner.co. They will generate all these documents for you. They'll send them to you as a PDF. There's very little wrong with the documents that I've seen recently from owner.co, or I can't speak to other of these registry services that are online, but they're decent records. Owner.co will remind you every year, oh, you should have an annual resolution, you should, of the shareholders, and we can help you do that. Where people find themselves getting into trouble or caught off guard is that your average, I have heard of pricing ranging from $600 to $2,000 for law firms or accounting firms to incorporate your company. Owner.co was somewhere between $400 to $500. So people are going to owner.co and saying, look at all this money I saved. I can assure you that you're going to pay sometime. And with some of these online services, what was catching me off guard is that they will incorporate you for a low fee, let us say $500. But the moment you want to actually add a shareholder or move shares, suddenly you have to upgrade your subscription. And that subscription upgrade starts to get up into, at one point, somebody reported to me that they wanted $1,200 to be able to upgrade the subscription so they could transfer shares from their mother back to themselves again. And so just be careful when you use these online ones. They're great. They'll give you all the documents you need, and they'll remind you that you need to do these things every year. But there's a price. And if you're not paying the price up front, then you're probably going to end up paying the price at the end. So just watch for that. Here was where I was talking about the registered and records office. If you want to incorporate and incorporate through your accountant or through your lawyer, there's some real benefits of them having their office instead of you having your house. One of the things that's most important is as the registered address where you can be served with a lawsuit. If you are sued, if you're sued in Alberta and you're in Alberta, you have 14 days to respond to the suit. If you don't respond within 14 days, then the other party can go in front of a judge and get a default judgment. Just you lose, is just to put it simply. So the last thing you want to do is to have somebody sue you by serving the corporation. And when you're serving a corporation, you don't actually have to hand a document to anybody. You can just drop that document off and have that placed outside the registered address. Well, in which case you're away on vacation, you come back and find that you were sued 3 weeks ago and you didn't have a clue. That's a real benefit at your accounting or your law firm, a lawyer's office. They get it. There's always going to be somebody at the accounting firm to receive it and to send you an email that says, hey, you've been sued. How about we just send a letter to the lawyer to say, we acknowledge that we've received it. Can you please take no further steps? Or worst case, you just file a statement of defense that said, yeah, what you said, no. That works. That works too. But more importantly, you're not going to be caught off guard by getting served documents that you didn't know were there because it's at your home and you were on vacation. And when you're on vacation, you always have somebody pick up your mail. It is rare to have somebody pick up your mail and open it all too to tell you what it is. So that when you're creating a company, having that registered office can be really important. Another common error is the Securities Act. I'm just going to start with the position that the law takes. You want to sell shares in your company? You can't. No. Period. Well, except if, and that's the law. That's the summary of the law. Can't sell a share except if. Starting with the position for anybody out there that's got a corporation that you can't sell a share unless a professional tells you is a good place to start. Now, the details on this are as follows. The law says you can't sell a share without a prospectus. A prospectus is a document that is anywhere between 50 to 200 pages long. It includes full disclosure of all the details of your business and the financials. And at the end of the prospectus, one or two people who are individuals are going to be signing, and they're going to be signing to say everything in this 200-page document is accurate. And if it's not, then you can sue us individually. That's what a prospectus is. It's a heck of a document to prepare, very expensive, very time consuming. The law recognizes this, and it has what are called prospectus exemptions. These prospectus exemptions are incredibly boring to read. They're located in National Instrument 45-106. If anybody wants to go and read 75 pages of what now, there's plenty of prospectus exemptions that are in there. If you want to sell shares to your friends and family, there's a prospectus exemption for that. You want to sell it to wealthy individuals, which are called accredited investors, there's an exemption for that. There's a sophisticated investor prospectus exemption. They're all in there. Some are better than others. Some have reporting obligations so that if you do transfer a share, you must report within 10 days to the local securities regulator, which in this case would be the Alberta Securities Commission. If you don't, then there's fines, there's lawsuits from the shareholders. The shareholders might actually be able to get their money back so that all the money that they put into the company, that they suddenly sue you as an individual and get that cash back. Frankly, there's even jail. So selling of shares is really dangerous if you don't know what you're doing. You don't have to be a lawyer to know this. There are securities professionals that are out there, dealers, for example, or brokers. I know of a number of CEOs of companies that know the securities exemptions better than I do. I'm not pretending that only a lawyer can tell you this, but if you don't know it, then you should be talking to somebody that does to make sure that what you're doing is okay. Thus, my starting position of don't sell shares unless a professional tells you you can't. Otherwise, you can get yourself into trouble. Taxes. It's good and it's bad, right? So corporations are independent people. The bad is that, well, as an independent person, it means that you're going to have to file another tax return every year. And the good thing, though, is that there are some additional opportunities for deductions available to a corporation that just don't exist for individuals. I hear, and I'm not saying this is true, but I have heard from tax professionals, and always consult your tax professional. Oh, hello. Always consult your tax professional. But there are differences between vehicle deductions between corporations and individuals. So an individual uses their vehicle for their business as a sole proprietor. then that individual has to add up all the mileage that they use for business versus all personal. They add up all their expenses, and then they can take a percentage of all their expenses off. If a corporation reimburses a person for the use of their vehicle, then they can simply reimburse as a reasonable amount. Nobody knows what a reasonable amount is. The tax CRA absolutely refuses to say what a reasonable reimbursement is. I've heard numbers that vary from everywhere from 39 cents a kilometer to 69 cents a kilometer. Nobody knows what a reasonable amount is. But the key there is that you're just writing a check by the company to the individual. Since it's a reimbursement, I don't think the individual, again, consult your tax professional, the individual doesn't have to claim it as income because it's a reimbursement. The company gets to claim it as an expense, which means they don't pay tax on the amount that they write that check for. That's fundamentally different than adding up your mileage, adding up your expenses, dividing the mileage that you used as the business from your expenses to come up with a number at the end. So there's some opportunities that exist in corporate world that don't really exist in the same way for the individual world. When the business is profitable, it is great to have that profit taxed in the hands of a corporation. It's wonderful because the tax is being paid on the corporate side, which means it's a lower tax rate than on the personal side. But when the business is losing money, and I've got news for everybody, most businesses lose money for their first few years. That's bad. That's bad because how is the corporation getting financed to be able to lose money in its business? Because by definition, there's less money in the bank account at the end of the month for the business than there was at the beginning. Well, the reason the reason that can continue is because some individual is writing a check to put more money in the bank account of the business. So you start up your company, you know you're going to lose $10,000 the first year, you incorporate, well, the corporation has a $10,000 loss. If you didn't incorporate, you did the business yourself as an individual, well, then you had a $10,000 loss, which you can use to offset against your income in your employment income. So the first few years when the business is losing money, it being a separate company is actually tax bad for you. It's actually better for you to be a sole proprietor, so that at least you can write off the losses of the company against your employment income. When the company starts to become profitable, well, then it's tax bad for you to be having that as a sole proprietor. You're better off to be in a company. Shareholders, sure, they're a great way to be able to distribute the profits, to get people to invest, to feel like people are participating in the company. And like that, I think it was Shakespeare that said it was the best of times until it was the worst of times. No, maybe that was, no, it wasn't Shakespeare, but it was close enough. Okay. So friends and families are oftentimes your first shareholders. These are the people that are easiest to get money from and who want to invest in you because they believe in you. And if you think COVID and politics is uncomfortable to talk about around the Thanksgiving and Christmas table, wait until you have an uncle turn and go, where's my money? Where's my money? Why haven't we become profitable yet? I want more details and information because I pay your salary. So friends and family relationships are a certain type of relationship. A shareholder relationship is a different type of relationship. And when you start turning friends and family into shareholders, it can strain your relationship. So be aware of that before you go off and just start cashing checks. Make sure you get everything on paper. The last thing you want is an uncle who starts remembering things different than you remember them. And although there are prospectus exemptions that allow you to sell to friends and family, it's super important to get these things documented, particularly as your definition of friends and family, because of the complexities of of marriage or divorce starts to stretch. You know, your uncle, the guy that you've called your uncle, might actually be standing on and saying to the Securities Commission 5 years from now, well, actually, I'm not their uncle. I'm actually the brother of the sister-in-law of the stepfather. And so, you know, getting things on paper at the beginning can be so important. That's where a professional can help you when you start selling shares. There's also documents, depending on who the individual buying shares is. There are some documents that they must by law sign to acknowledge the risk that they're taking by investing in the company. These risk acknowledgement forms are not just a good idea, it's the law. So a professional is going to be able to help you do that if you do create a company and want to give shares to people. Shareholders agreements are so important. A shareholders agreement is a little bit like a prenuptial agreement for married couples. A good shareholders agreement sets out the expectations of all the shareholders with each other. They set out who's going to be running the company and who's expected and who's not expected to finance the company. And more importantly, and the most important, is that they have breakup language in them. The last thing you want to do is to bring somebody into a company, give them shares, and then realize that you're not working well with each other, but have no choice but to work with each other. A shareholders agreement can say, look, we're going to have some clauses in here that if it hits the fan and we don't want to work with each other anymore, we're going to have a process of how we unwind this in a stepwise and reasonable fashion. Great thing to do at the beginning of the relationship, really tough thing to do at the end of the relationship if you haven't already got an agreement in place on how you're going to unwind. Finally, and this is probably the most important thing for anybody who goes off and incorporates, what is the company's property? Make sure that you have a clear understanding of where the company starts and where you end, and then make sure that you're actually following that in agreements. So a lot of times entrepreneurs will create a company. One of the reasons they create the company is so that they don't become liable for the company's debts. Well, I've got news for you. Service providers are onto this. They know this. So you can go and get supply agreements. Paper company, for example, was the one I saw last time. It was a paper supply company that was going to deliver photocopy paper once a month to a company that had a lot of photocopy. And at the end, there was this one line that they had me read. And the contract essentially said, this company is going to promise to pay for the paper it gets. This company is going to order this much paper. This company will pay within 30 days. And then there was a line after it that said, the individual signing this document agrees to be responsible for any amounts the company doesn't pay. Well, that was a sneaky one. In this case, the company in question that was ordering the paper generated about $150 million a year in revenue, and the person who was signing the piece of paper was a mid-level person that worked in the accounting department. But that person was signing a piece of paper that said they would be responsible for the debts of their employer. There are a lot of sneaky little contracts that are out like that. Sometimes I'm the one reading them. Sometimes I'm the one writing them, to be honest. Be aware of what you're signing and making sure that they're in the contracts, in your service agreements, in your supply agreements, that it is super clear of who they're doing business with, and if you've created a company that they're not doing business with you.
I think Craig's internet is having a blip.
With your business. Make sure that you have a clear document that says who owns that. Because at some point, and this is a separate talk of mine, is getting ready for investment, an investor is going to come in and ask the company, what does it own? And the company should have its own bank account. It should have a lot of paperwork that shows that the company owns its brand, it owns its website, it owns its inventory. Make sure that it's out there. Ideas and trade secret ideas, make sure that the company, if the company's the one doing the business, make sure that the company's the one that owns this. It's going to help you a lot when you go off and are seeking investment or trying to sell. Even inventory. Inventory storage. Where are you storing your inventory? Do you have control over it? So if you are operating out of your apartment and you have 3 roommates, and you don't have, one roommate collects all the money and pays the landlord, and your business is operating out of your room in the apartment, one day you come in and you find that the locks have been changed and all of your inventory has disappeared. Well, you go, but that's not my inventory, that's the company's inventory. Well, the answer under law is, if your roommate wasn't paying rent, then the landlord gets to seize those materials and gets to sell them to make up rent. If you can't prove that that material that was in your apartment was actually somebody else's, namely the company's, then they're going to say, no, that's ours, and I'm going to start selling this soda. I'm going to sell all these soda cans to my friends and neighbors to be able to pay for the rent. You want to be really clear of who owns what, so that you can actually protect it in situations where you want to protect it. So I think this is the final, lessons to take away. There is no easy answer for when you should incorporate, but there's a whole bunch of information that you should have of the kind of things you should be thinking of when you incorporate. There's not one size fits all, and more importantly, there's not just 5 pieces of paper and you are incorporated. There's more than just the 5 pieces of paper a registry office gives you. You do have to do things on a regular basis. You do have to have documents that are prepared by law and maintained by law. So keep that clear. It can protect assets of individuals. That's for certain if you're set up correctly. If you're the sole shareholder, director, an agent, and officer, then are you really protecting your assets? Perhaps from creditors, but not necessarily from people that you've done a wrong to. So where people who might sue you. Make sure you do the paperwork right to get the assets clear, and that you're signing any credit applications, or when you open a bank account, it's very clear what you're responsible for as an individual and what the corporation is responsible for. And perhaps the most important thing is don't just put different labels and cans different labels on the cans of soda and laxative. Make a very different shaped laxative can. Make it a different color. Don't just slap on a sticker, because otherwise there's somebody at a balloon that might be very upset at you. And that, I think, is the end, which is perfect. We only have a short period of time for questions, but I'm happy to answer any questions anybody might have.
There was a question from Ash in the comments.
Well, look at that. Okay, well, it never moved. My apologies, Ash. Does at arm's length play a role? Oh, Charles Dickens too. I like Ash. Okay, no, that was Cecile. I like that was Charles Dickens. Ash, I'm sorry. I don't know when arm's length was featuring into here. Arm's length transactions with respect to what? Tax? Because tax is really big on at arm's length. You know, I don't blame Ash for ignoring me, because I did ignore her question because I didn't see it pop up, even though I said it would.
Feel free to go off mute, Ash.
Oh, yes, tax. Just learned arm's length in class. Okay, so the Tax Act treats transactions that are not at arm's length differently than transactions that are. In essence, if you are bargaining in good faith with an individual that you're not related to in some fashion, the tax authority is going to treat that in a fashion different than the tax authority is going to treat a way that you've done a deal with your wife or your husband or your mother. So arm's length is all about the tax authorities treating those transactions different, and then sometimes just attributing money that somebody who's not at arm's length receives to as if you'd received it yourself. Okay, bear with me. Big question here, which I love the big questions because they make me sound smarter than I am. If you're a sole, so the question is, if you're a sole owner operator, there may not be many advantages to incorporating when it comes to protecting your assets if sued due to a product issue, unless you otherwise protect your assets under a separate corporation. It depends on what the suit is. So if you're sued because the company didn't pay a debt, then there is a protection for the director, there's a protection for the shareholder, there's a protection for you to incorporate. If you're sued because of something wrong, some act of wrong or harm that somebody received other than a debt, then the benefit of a corporation suddenly disappears because some individual had to have done that wrong. And because of that, the protection kind of evaporates when you're a sole director and shareholder. It's still there for debts. It's still there for you incurring debts or owing people money. But when it comes to harm that people actually have, then that protection disappears quite quickly. It comes back, by the way, as your company expands. So you hire an employee, the employee goes door to door and punches somebody in the nose. Well, the question would become, are you liable as a director for an employee punching people in the nose? And the answer generally would be no, not unless you knew that they were violent and you had warnings, or you had a business process that said if somebody says no to buying soda 3 times, you can punch them in the nose. Those are the kind of things where a director might be liable. An officer of the company who supervised the employee might be liable in that kind of weird circumstance. But generally, if an employee harms somebody, they harm somebody in a way that you couldn't have reasonably expected as the employer to happen, then you are protected as the shareholder and director and officer from the acts of that employee. Your personal house. Oh, yes. Well, so personal house, that comes down into what can people go after? If they sue the company or they sue you, how much of you can they get? And that's a different area of law. It has to, people say, I'm going to lose my house. Well, it actually depends on how much of your house you have. It depends on who's claiming the money from you and why. But if you've got a house where there's only $5,000 of equity, that's different than if you have a house where you have $250,000 of equity. So it can be a little bit different depending on what the situation is. Civil law, also different areas. Civil law. Yes, tax. Just learned it in class. Oh, and arm's length in civil. So there's the law, not just the tax law, recognizes at arm's length and not at arm's length transactions differently, and the same goes for the civil law, where the courts will treat that differently too. Is there a dollar figure on profit that would be a trigger to incorporate? No, because it depends on what the individual sole proprietor's situation is. So if there's like 3 factors that come in. How much are you making as an individual elsewhere? How much do you need to live off of? And how much profit is the company going to make? And that's kind of the 3 things that we try to consider before we come in, say, for tax purposes, you should incorporate. So I can't really give you a dollar figure. What I can say is that I think our highest tax bracket for individuals right now is $110,000. That's so anything over $110,000 per year. Actually, open up a spreadsheet I did just a few weeks ago to check. But the key factor has to do with how much individual income you're making, what the consequences are for keeping the money on the corporate side versus why you might want to get it into your private side. I've been told by accountants that you should talk with an accountant when you get to the $80,000 to $100,000 range for profit. Absolutely, because that $110,000 mark for the highest tax bracket as an individual, if you're making $80,000 to $100,000 from your company, it doesn't matter how much you're making in your other side job, you're in the highest tax brackets, and so there's some benefit there. How would liability insurance work in tandem with incorporation limitations on liability? Insurance first to cover and then can be sued personally as a director. Depends on what the lawsuit is over, and it depends on what your insurance covers. If we just take the simplest case where a company has done some accidental wrong and that there wasn't gross negligence or willful misconduct in it, that it just happened, right? You checked, the can was supposed to be soda, but the actual bottler was the one that slipped the laxative in there, then your insurance generally will cover it first, and it'd be highly unlikely that there would be any personal liability to any of the individuals that were acting on behalf of the corporation. Have another question here. If you are a sole owner, decided to incorporate and have liability insurance, in the event of a lawsuit from a customer, the corporate veil is lifted. Does the corporation liability insurance help the agent in this case? So the lifting of the veil is actually a rarity. It's a special circumstance where that corporate veil is lifted. Somebody clearly was picking that up from class. So the corporate veils are lifted only in rare circumstances, and the lifting of the corporate veil, by the way, means that the court is going to push through the paper and that documents what a corporation is. It's going to push through that, and it's going to attribute liability to some individual on the other side of the company. Usually it's only in situations of fraud or deceit or some really inequitable conduct that's going on that the court is going to lift the corporate veil. Most times, smart lawyers who are suing will not call upon the court to lift the corporate veil because it is such a big deal when they do it. Instead, they'll work hard to actually find liability on an individual and liability on the corporation, instead of just trying to attach the liability to the corporation and ask the judge to push through that veil. It's just better strategy that way. Can one use a post office box for an address? I don't know. There was a rule where directors' addresses couldn't be post office boxes, but there's been a lot of changes since the UCP came in. Things I never thought that would be needed or be done, and some of them are good. Some of them make me raise my eyebrow and go, "Oh, what now?" I can't tell you about post office boxes since it's never come up in my practice because I never use a post office box. I'm sorry. Is there more opportunities for expense deductions as a corporation or staying self-employed? Yes and no. Yes and no. It really depends on the circumstance. It really does. So a lot of people like to, particularly in the loss stage where a company isn't making much money, they love to be a sole proprietor or self-owned because of all the expenses that they can do. But there are certain situations where either A, you're working on old or bad information. That's a real problem. And when it comes to tax deductions and any tax planning, is that somebody's father always told them, run a company out of your home because then you can write off the spare rooms. That's bad advice. And how do I know that? Because my dad told me that, and he's wrong. Maybe at one point you could, or maybe at one point people got away with it, but there's a difference between getting away with it and it actually being consistent with tax law. So it's really going to be a situation by situation case. It's going to really strongly depend upon what your business is, what your personal circumstances are. It all factors into that. Talk to a tax professional. Rarely would you be a benefit to talk to a lawyer either, unless the lawyer is also concurrently a tax professional, in which case you're paying a lot of money. They charge at rates that make me blush. But a good tax professional, a good accountant will be able to give you some decent advice. And that advice is going to be really targeted to both your business and your personal circumstances. Boy, those were good questions. You had me running there, guys. I love that. Thank you very much. Health plans might be an example of an expense a corp can get over a sole proprietor. Certainly that is an example. Dale, you're full of good ideas today. Also, access to health plans was also very important at one time, that you could get access to benefit and health plans where you couldn't as a sole proprietor. A little business called Costco changed the shape of that, where for just a slightly more expensive Costco membership, you can access Blue Cross and other benefits plans through them. Now, whether that would be a deduction or not becomes a different question. But at one point, there was not only deductions of health plans, but also access to health plans that corporations could have. But Costco is your friend when it comes to that if you're thinking of starting a business.
Wow, lots of questions.
Lots.
Any more questions before we let Craig get back to his busy schedule?
I know that there's a St. Bernard that needs a petting.
It looks like we're good. So thank you so very much, Craig, for leading the session for us today. Everyone, I will be sending out a survey, so please do take a minute or two just to answer the questions. Helps us plan for the future and keep things on track and meet your needs. Everybody have a great day, and the weekend's just around the corner. Again, thank you, Craig, for helping us.
Thank you, everybody. Thank you for your kind words, Dale. Much appreciated. Everybody have a good afternoon. Thanks, Cecile.
Thank you.